Hello everybody. Hope you're doing well today. Welcome to our webinar, What Families Need to Know About Planning for a Loved One with Special Needs, a very important topic and one that we're very passionate about here at Elville and Associates. We offer this presentation about 20 times each year and are very pleased to be with you today. A little bit about how this will work today. You are on mute. However, if you have a question, please note it in the box on the right-hand portion of your screen, and I'll find an appropriate time during the webinar to interject and pose the question to Steve during the presentation. We'll also have time for questions at the end. You received the presentation ahead of time for your convenience to take notes if you wish, and also you received an evaluation form this morning by email. So please take a couple minutes to fill this out and email it back to me. You can fill it out through Microsoft Word and tab through it very easily, and you can save it and send it back to me at jeff@elvilleassociates.com. That's Jeff. This is your opportunity to offer us feedback about the presentation and also request a time for a free consultation with Steve to discuss your family's planning needs. And we certainly want to be a resource to you, and there's nobody better to guide you through the planning process than Steve. So just a little bit about the firm, if you're not familiar with us. We were founded in 2010 in Columbia by Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here: estate and special needs planning, elder law and elder care planning, estate and trust administration, asset protection, guardianship, and tax planning, among many other areas. We have 7 attorneys, 12 staff members, and 5 locations. We're currently coming to you live from our Columbia location off Gateway Drive. Our mission here at the firm is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We focus a lot on education here at the firm, and we do that in a number of ways through our planning process with our clients. We offer over 100 educational workshops among all of our attorneys in the communities we serve each year, and we have a very strong accredited client care program that furthers that education that many of our clients take advantage of as well. So I have the pleasure of introducing today's speaker, who many of you know, Mr. Stephen Elville, President and Principal Attorney of Elville and Associates. His work is centered in elder law, special needs planning, and estate planning, with special emphasis in the areas of tax planning and asset protection. He's a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. And he works to bring peace of mind to clients by creating solutions to their needs through counseling and education using superior legal technical knowledge. He was also last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar. He's a very seasoned speaker, speaking at about 75 different presentations, workshops, webinars, continuing education events each year. He was also named to the Maryland Super Lawyers list for a 5th time in 2020. So you're in very capable hands today. So I'll turn it over to Steve right now.
Good morning. Thank you, Jeff. And good morning, everyone. I can't see you all out there, but I know you're there. And I want to thank you for being here today on this webinar. I also want to thank Jeff for the wonderful job he does to orchestrate these and be the moderator. And he'll be moderating throughout the presentation. I just hope everyone is safe and well this morning, wherever you are. I have indications in the last 24 to 48 hours that the situation here in Maryland is still quite serious, and I know it is everywhere. But from contacts I have at certain hospitals to other attorneys and clients that have lost loved ones. So I hope everyone is staying very, very safe and cautious and well. So we're going to get through this, but it's going to take some doing. And Elville and Associates is still operating and doing the things we do, taking care of clients and working in our 3 major practice areas, although we're doing it on an adjusted basis, and we're doing it with extreme protocols to keep everyone safe, the clients and families and ourselves. So with that said, we're here today to learn about special needs planning and planning for loved ones with special needs. And Jeff has given me control of the slideshow, so I'm actually going to try to move it forward. Jeff, I'm having a little bit of trouble doing that. Maybe you could advance the slide from your end. And we'll just have a little bit of a hiccup here as we get started.
Um,
There we go. All
there we
right.
go. Okay.
All right, now I'm in control, so thank you, Jeff. So here's the start of our presentation, and I want you to feel you can ask questions at any time, just like Jeff said. And with that said, we've got a lot to cover, so I'm just going to get started. Um, so why plan? Well, there's lots and lots of reasons why people do planning, but for planning with loved ones with special needs, you're going to have your own particular circumstances that may be driving it, whether you're a parent, a grandparent, or a friend or other relative of a person with disabilities. But basically, the core reason for planning is really to enhance that person's quality of life and protect that person throughout their lifetime and help them maximize their potential. And I think many of you will resonate with that. I like to think of it in terms of we want to utilize whatever we might call the public benefit system or the means tested benefit system in this country. And hopefully we will always have that in place. We want to use that and utilize it in most cases, but we also want to create a world for the disabled person where they will have a backup set of protections or enhancements to their lives above and beyond means tested benefits. So lots of reasons why we want to plan. We want to be thinking through those reasons because all planning is goal driven. Here are some of the benefits of planning. I'm going to minimize something here. Just hold on. There we go. Providing for security. We talked about leveraging means tested benefits. So that's something we want to study and know about. The average trustee that is a trustee of a special needs trust, for example, probably doesn't fully understand the public benefit system. That's something we want to understand and leverage. We want to have a team of advisors. This might include a financial advisor, a CPA, in addition to your special needs or elder law attorney. It also might include an advocate, a person who's going to advocate for the loved one with special needs. Many of you are concerned about planning for housing, and maybe you're going to leave your current residence in trust for the benefit of a disabled person, or maybe you're going to be depending on public means or what I would call agency-related supported housing in the community, and there's nothing wrong with that, but that's a big topic of discussion. Who's going to advocate for your loved one in the future? Do we have that in place? Is it going to be relatives, and in most cases it will be, or is it going to be outside caregivers or advocates or a waiver program? So we need to talk about that as part of the planning. And of course, that's related to caregiving needs and coordinating with an entire extended family plan where family members are involved. And I know many of you are aware that in not all cases are family members involved. There are cases where family members are not appropriate to be caring for a loved one. So that's all part of the thinking. Protecting the beneficiary from creditors or predators or vulnerabilities or fraud. These are all things that are part of proper planning. And for some people, and maybe for many people, preserving assets that have been left for someone with special needs, preserving those assets for other family members, God forbid, should the person with special needs pass away. So all of these things are one big set of counseling issues that need to be considered in planning. Jeff, let's go ahead and advance the slides again.
You should have control of the screen there, Steve. If you need help, I can come over real quick.
Yeah, I think I have a problem. So I apologize, everyone. We're going to get our technical difficulties handled here. I'll just say a few more comments about the last couple of slides. So what we're going to cover here in the next several minutes and the next 10 to 20 slides is a whole system of how we begin to start thinking about these issues. Yes, Jeff. So I'm going to now let Jeff sit here. We're going to social distance, and he's going to fix the problem here.
Okay, now all right.
Thank you for your patience. So Jeff has fixed our technical problem, and I'm going to go ahead and advance the slides now. So successful planning has to do with having the right team. And here's something that we haven't talked about yet, and that's building flexibility into the plan. So far we've talked about why plan, what is some of the philosophy of special needs planning, who are the types of advisors that might be involved in that kind of planning. Now we're talking about flexibility. That's one of the big issues, is building in flexibility, which I'm going to say 99% of the time is the case with our clients, that when we're putting these plans into place, we don't want them to temporarily work for a period of years and then for them to become stale or out of touch with the law. We want them to be flexible and be able to be maintained and be viable for the years to come. So we talked about the advisory team. We've talked about advocates. Here's a concept I want to introduce to you. It's part of flexibility, and that's the idea of a trust protector. So some of you are familiar with trust protectors in your own modern documents. For those of you who are not familiar with trust protectors, this is a special fiduciary that would be a person who would be included in a special needs trust as a person who is given certain flexibility powers. For example, powers to change trustees if necessary, power to appoint an independent trustee, the power to amend the special needs trust if it needs to be amended in the future. So this is a very important role, and it again adds dimension to a trust and adds flexibility to a trust. Many of these things are a little challenging to think about if you've never heard of them, and we want to take the time in the planning process to evaluate and think about these choices and these overwhelming issues. All right, so let's talk about what it takes to actually do what I just described, which is take our time. We want to take the time to think. Jeff and I have talked a lot about this in 2020. We want to encourage clients and families to slow down and really take the time to think about these issues. Hopefully things will go back to normal and we can think about things in the comfort of a conference room like the one I'm sitting in. But if not, we're going to be doing a lot of telephone consultation, a lot of video conference consultation, and we want to be thinking. So again, what types of care, who will our loved one live with, and who will support them? Is a guardianship or conservator required? This is an issue we're going to get into here in just a little bit. How many of you have heard of supported decision making as an alternative to guardianship? This is something I want you to Google, to search and find out about supported decision making. Supported decision making is a possible alternative for certain people who with disabilities to give them more self-determination over their own lives, to be able to make a lot of their own decisions with the support of someone without a guardianship necessarily. So these are things I want you to know about. Who else will be involved? Will there be others other than trust protectors and advocates? Will they be needed? What kind of lifestyle do we want for our loved one? What are the future challenges that we can conceive? And building layers. We talked about the public benefit system, so to speak, the means tested benefit system, and what kind of a world do we want to build beyond that? This is something you can actually think through, again, with a certain kind of process and purpose. Now, one of the things that I think is one of the most important elements of special needs planning that I can bring to you today is the idea of creating a memorandum of intent. Some of you who may have done estate planning with our firm or other firms may have heard of this concept of creating a memorandum or a letter of wishes, some people would call it, to attach to a will or trust, to give some informal input about what your goals and values are for your estate plan. Well, in a special needs planning, this is essential in our view. We want to take the time to create a memorandum that's going to talk about many of these things on the slide. What are your loved one's preferences? What are their particular needs? Who are the physicians involved? The idea here is to paint a picture of not only what you want to happen for the benefit of your loved one, but to give a potential trustee in the future who may or may not have any idea who your disabled loved one is and what they're like, what their preferences are, to give them, that person, that trustee, or even that trust protector, to give them some idea of your wishes, your intentions. So I strongly encourage you to think about this. You can create your own memorandum of intent. Jeff and I are happy to send you a template that we have. It's kind of a starting point. It's about 20 pages. It's not easy to complete, but we want you to take this template. If you want to see it, we'll send it to you. And we want you to develop possibly a Word document or another word processing document that can easily be updated over the years. So this memorandum would be attached to the back of a special needs trust, for example, and would kind of be a living, breathing version of what your intentions are, your wishes for the future for your loved one and for the trustee. So strongly recommend that you do this. I've had families provide only a paragraph of instructions. I've had families that have a catastrophically disabled loved one create entire manuals of how to care for that person. So memorandum of intent, one of the big issues in a special needs planning today. So what are the steps we should start taking? Well, again, it's a very broad subject, so I know you're taking all this in. We want to estimate income and expenses. We want to start thinking about how much money is it going to take to provide for our loved one. I want to encourage you to use the resources of financial advisors for this. We deal with many, many financial advisors of all kinds. If you don't have one, my experience in special needs planning is that many families with loved ones with special needs have no financial advisor connection. So we're happy to try to help you interview some financial advisors and see if there's someone who can provide resources and help to you. But for example, making projections, talking about life insurance as a funding tool, talking about how are we going to make sure there are funds, that there are assets in that special needs trust at some unknown time in the future. The problem, as you can imagine, is many of us have to plan for today. We can only really plan for today. In other words, how much money will I be able to leave my loved one if I were to pass away today? So that's what the way many of us think about it, and somehow we're forced to think of it that way. But in reality, we really don't know how much money we're going to have in the future at the time of our death. How much is it going to cost for us to have long-term care, our long-term care needs met? How much is it going to cost for us to retire? So that's why life insurance, and in particular permanent life insurance, may be the best funding tool. That in a perfect world, all special needs families would have life insurance funding a special needs trust. But of course, lots of families today have retirement type assets that are funding special needs trusts, not just life insurance. But this is the big conversation, and this is something that should have financial advisory advice as part of your team. So we want to be thinking along those lines. We want to use resources that are available to us. Some of these slides I won't spend a lot of time on. They're just for your use and benefit, like these simple spreadsheets. And then we want to think about the potential incapacity of our loved one. And, you know, the issue is here, who will make decisions for them? So hopefully we as parents or grandparents or aunts and uncles, hopefully we have taken care of our own estate planning, our own will, our own trust, our own powers of attorney. But what about the disabled person? Do they have the mental capacity and are they not vulnerable, and they are the kind of person who could sign their own power of attorney for financial purposes, their own advanced medical directive for healthcare purposes. And in those documents, what are they doing? Well, they're mainly naming their healthcare agents, they're mainly naming their financial agents, and now we could, in theory, mostly avoid the issue of guardianship. On the other hand, many persons with disabilities are not suited or not suitable or do not have the mental capacity to sign powers of attorney and advance directives. and adult guardianship is appropriate for this person, for that person. So we talked about that a little bit, and now we're getting to it again, the issue of supported decision making, which is a fairly new thing. It is not the law in Maryland, but to give you an idea, it is the law in Delaware and in the District of Columbia, in Alaska, Wisconsin, Indiana, and Texas. I may be missing another state that I'm not recalling right now, but those states have supported decision making, and in essence, it is a way for a disabled person, again, to be able to control more of their own lives. I'm involved in a project right now that has to do with trying to help others get this into law in Maryland. But the way I would look at it now is your disabled loved one can either sign their own incapacity planning documents if they have mental capacity to do so after age 18, or we need to consider at age 18 or beyond, we need to consider, I'm going to get rid of something that just popped up on my screen, excuse me. We need to consider adult guardianship of the person mainly, or of the person and property. Hopefully in the future in Maryland, there will be a middle ground, and that is the issue of a disabled person being able to appoint a supported decision maker. So if you'd like more information about supported decision making, I hope you'll email me and email Jeff, and we will get you some information on how to find out about this particular movement and how to support it. All right, I'm now going to go to the next slide. And there we go. So now we want to just spend a few minutes talking about public benefits. So when I'm talking about public benefits, I'm talking about a very broad topic, the types of benefits that are available to certain people in certain categories of disability. So I'm hoping that you can see all three of these categories, and I hope that my GoToWebinar screen is not blocking any of those. On the left side, we have means-tested public benefits. In the middle, we have entitlement benefits, meaning Social Security, disability, and so forth. On the right-hand side, we have other benefit programs, such as Section 8 housing and veterans benefits. I'm not going to spend too much time on that right-hand side, but I will mention it briefly here just a minute. We mostly want to focus on the two other categories. So if you'll allow me to, I'm going to just categorize the types of special needs beneficiaries that I think we see most often in special needs planning for the purpose of your understanding. So let's talk about the left side here, means-tested public benefits, SSI and Medicaid. Many of you on this conference webinar have children who are disabled. They are receiving SSI, usually after age 18. It's $783 a month in 2020. In some states, there's an additional amount that is supplemented. But SSI is the quintessential definition of disability, supplemental security income. A person who receives SSI automatically receives Medicaid. So let's talk about that for just a second. I'm going to stop there for just a second and break this out into three different categories. So bear with me, we're still talking about Medicaid. So I want you to think about Medicaid in three ways. On the left side, if I were to hold up my left hand, I want you to think about what I would just generally call community-based Medicaid. This is the type of Medicaid someone would get if they had no income or low income and low assets. This is the kind of support we would get in the community, public assistance basically through the Department of Social Services. In the middle, we have the waiver programs, which I'm going to talk about in just a minute. And on the right-hand side, we have long-term care Medicaid, as if I was in a nursing home and I needed long-term care skilled nursing. So three types of Medicaid. The one on the left-hand side, so to speak, is community-based Medicaid. That is unlimited according to federal and state law if I meet the criteria for that. If I'm in the community and I need that Medicaid, I'm going to be able to get that. On the right-hand side, if I spend down my assets appropriately and I'm in the community and I need long-term skilled nursing care in a nursing home, through state and federal law, that is going to be paid for on an unlimited basis. In the middle is this category we call the waiver programs, and many of you are familiar with this because perhaps your child is on the autism waiver or one of the other waivers through DDA. And of course, there are other waivers like the older adults waiver or the traumatic brain injury waiver and so forth. So these are waiver programs. What does that mean? It means that the federal government gives the states the right to choose not to provide unlimited services, but to provide only limited amounts of service based on the state, each state. So the waiver programs are limited, and many of you are already familiar with this concept. So just know that when we're talking about Medicaid, we're talking about different kinds of Medicaid. And in this particular context of special needs, we're usually talking about community-based Medicaid or the Medicaid waivers, okay? So let's go back now to this slide. We got away from that for just a second, but now that we have a little bit of a definition of Medicaid for our purposes of this discussion, let's go back to this first category, a person who's receiving SSI and Medicaid. So this person is getting means tested benefits. They can only have $2,000 in their name as an asset or resource. And if they have more than those assets in their name, they are overscale or over-resourced and they will lose their benefits. So this kind of person, when we have a special needs trust, the trustee needs to make sure that they are not doing something by giving the beneficiary money in such a way or benefits in such a way that the beneficiary will lose their SSI. So that is that first category. The second category is the Social Security disability category. And I know this is a lot of information, so if you're getting a little bit confused, you may ask questions at any time, but just keep bearing with me. This is a person who either has their own work record and they're getting Social Security disability based on their own work record. You may know a young person or not so young person who has a work record and now they're on Social Security disability based on that work record, okay? Or they may be getting this benefit as a disabled adult child. They may not have their own work record necessarily, but they're getting the benefit based on their parent's work record because the parent is either retired or the parent is deceased. And so as we're going to see in further slides, the person who is receiving a disabled adult child benefit is a person who was disabled prior to age 22 and their parent is either retired or deceased. This person is receiving 50% of the amount that their parent receives of Social Security. And at the parent's death, this person is going to receive 75%. So here's where the first category and the second category here are tied together. And this is worth the time. A person might, after age 18 mostly, receive SSI and then become entitled to disabled adult child benefits when their parent is retired or deceased. So the person who's on SSI may graduate over to receiving SSDI someday. And when they do, they will switch from Medicaid to Medicare. So many of you are familiar that when someone receives Social Security disability, they will, by virtue of that, receive Medicare eventually after about 25 months. So the person who receives Social Security disability and Medicare, and this is where it's a little confusing, may still also receive Medicaid. There are people who don't just get Medicare and Social Security disability. There are many, many people who get all three: Social Security disability, Medicare, and Medicaid. So a person who is on a waiver program or is on other means-tested programs where they cannot have more than $2,000 of resources in their name, that person, even if they are a disabled adult child, even if they are in this middle category, that person will still continue to receive Medicaid and have a Medicaid card. So that is something that many people do not have their minds around. And I wanted to take a few minutes to try to explain the difference between the types of Medicaid, generally, very generally speaking, and what the difference is between these first two categories. The third category here, which has to do with veterans benefits and Section 8, we're not going to spend too much time on this. Section 8 housing, there's nothing wrong with it, but ideally, we would prefer that our special needs beneficiary does not live in Section 8 housing because it is sensitive to the distributions that are made to the beneficiary. In other words, if a beneficiary receives money from a special needs trust or money is paid for the benefit of a person from a special needs trust that is in Section 8 housing, it can and will increase that person's rent. So it's not an ideal situation, but many people do live in Section 8 housing. It's something that a special needs trustee needs to be aware of. So speaking of educating trustees, I'm going to take this second here just to ask Jeff if we have any questions, and I'm also going to give you the name of a book I recommend, and we hand this book out to many of our clients and special needs families. It's called, and don't take the title too seriously, How to Administer the California Special Needs Trust. How to Administer the California Special Needs Trust. You can buy that book on Amazon. It's written by a gentleman named Kevin Urbash, U-R-B-A-T-S-C-H, who's a wonderful man, and he's also the past president of the Academy of Special Needs Planners. I find that particular book very insightful for trustees and families to get a very basic understanding of what to do as a trustee of a trust and how to understand the world of special needs planning. If you see the book, don't get too put off by the fact that it's very thick, because the writing is, the words or the letters are big.
So Steve, we do have one question. If you could please repeat the states that are currently using supported decision making.
Very good question. So I will, to my knowledge, these states are DC, District of Columbia, Delaware, Indiana. Indiana has a wonderful set of laws about supported decision making. Wisconsin, Alaska, and Texas. I can personally tell you that just from my research, because I'm involved in a documentary film project with folks who are trying to get this in front of our legislature here in Maryland, I can tell you that my research has shown that Indiana has wonderful support materials if you want to go online and see that. And also Alaska has videos and other support materials. And if you want to know more about our project, please let me know, because I'm happy to tell you more about that.
So there may be right now, Steve.
All right, thank you, Jeff. Okay, so SSI, how to qualify for that. I'm not going to spend a lot of time on this presentation about the qualifications. Just know that there's a resource test and a disability test, an income test. These are some definitions of disability and what is substantial gainful activity and so forth. We talked about the resource limits. This also applies to a couple. I had a couple one time years ago that were in their 70s, and they were living in a high-rise complex in Montgomery County, and they were both receiving SSI, and they had resources of under $3,000 here. So you can see that that's not just for individuals. Now, many people are surprised when they find out that a person on SSI or means tested benefits can still own a home. So it is possible a disabled person can own a home, they can own an automobile. I'm not saying they should own the home in their own name. They may be vulnerable to others and have no business owning that home in their own name. They maybe shouldn't have any business driving, but just know that they can own these resources, and it does not disqualify them from SSI, including furniture and belongings, burial plots, and so forth.
We do have another question, Steve.
Yes.
Which I don't think we've ever had before. The question is regarding SSDI. If you have two working parents, which Social Security account is used?
That's a great question. I believe it's going to be ultimately the person who has the highest benefit. But if you'll email me that question, I will get an answer from our resident expert here, Megan McCullough, who is a wonderful Social Security lawyer. All right, SSI, we know it's $783 a month. We know that some states like California have a supplement to SSI. What is SSI for? It's for food and shelter. And you know, we sit here in 2020 and we say, well, gosh, how can someone live on $783 a month? But the government meant this to be for food and shelter. Perhaps in the future we're going to see tremendous increases in these amounts, or increases in the amounts that of resources a person can have without being disqualified, but nothing on that front yet. Now, once a person is on SSI, we know that they could potentially lose their SSI. This is one of the things that I find over the years with thousands of special needs families that is very, very concerning for parents who want their children to be productive. They want them to be able to work. They want them to feel happy. And yet, if the child does work too much or just does earn too much income, the child can lose their SSI. So I won't go into these formulas. I'm going to let you review that, but just know there's a difference between earned and unearned income, and how SSI could actually be reduced to zero. And we don't want that to happen because we don't want the person to lose their Medicaid. Now, some of you have already experienced this perhaps, that your disabled loved one is living with you and you're taking care of them. Well, you are providing maintenance and support. You are actually giving them food and shelter. So what Social Security will do is they will reduce the 783 by the maximum amount, and that's 1/3. So we know that the worst that can happen, unless this SSI is being reduced because of earned or unearned income, we know the worst that can happen is that Social Security can reduce that by 1/3. If the child is paying rent, which is counterintuitive to some parents, then the Social Security Administration will not reduce it by 1/3. So we want to avoid, if we can, losing the 1/3 for in-kind maintenance and support or deemed income. Social Security disability eligibility, I'm not going to go into this a great deal, as you can read these slides. And what I will go into here a little bit is the disabled adult child benefit again. So for those of you who were trying to keep up with what I was saying back there a few slides ago, this is that situation where someone is disabled prior to 22, and they will receive this benefit, which is a wonderful thing. They will probably get an increased benefit in most cases from the SSI. There's no resource test, and they'll get 75% forever, basically, at the parent's death. So this is something to know about the disabled adult child benefit. Again, Medicaid and Medicare, this is more supplemental information for you. I'm not going to spend a lot of time on this. We talked about Section 8 as being a concern. I'll give you an example. We had a recent client situation where a family was giving their loved one some financial support who was living in Section 8 housing, and Section 8 did what they're supposed to do under the HUD rules. They made this person declare those gifts as income, and as a result, it increased the person's rent quite a bit. One way around that, and we're going to talk about the ABLE account a little bit later, but one way around this, which is the most powerful thing I've heard in quite some time, is that had the family, and they are now doing it, had the family been giving this person money through an ABLE account, that this person that has mental capacity, but he has disabilities, if they had contributed that same money to him on a monthly basis, but had put it into an ABLE account, and of course that's capped at $15,000 per year, but let's say they had put the money in the ABLE account, it would not have increased the person's rent, and they are now using that technique instead of giving him money outright. So the ABLE account, which we're going to talk about a little bit later, it is very powerful for certain uses and to enhance the quality of life of a person. So again, housing is one of the biggest worries I know for you as parents and grandparents. Just know this is a big part of consideration of counseling in special needs planning. All right. Now, again, this last slide here on housing, should you purchase a home for your special needs loved one, should their trust own the home? And in most cases, 9 times out of 10, the special needs trust will own the home. There's lots of factors to go into on that, but just know common sense most of the time is going to dictate that the house for the disabled loved one, excuse me, will be owned by the home, by
So,
the trust.
so Steve, as we get into the special needs trust area, one question, if you could keep in mind as you go into this, is does a special needs trust keep the assets from being visible as assets in terms of losing benefits? She's not sure if that's being asked correctly, but I think you probably understand the question.
Yes, that is asked perfectly. So thank you for that question. So what we're going to see next is that the use of a special needs trust will shield the assets that you're leaving to a special needs person or a person with disabilities. It will shield that person from losing their public or means tested benefits, including waiver benefits. And that's the whole purpose of the trust, other than protecting the person from fraud and so forth. So any assets left to a special needs trust in the proper way, those assets will not be available. They will not be considered available resources for means tested purposes for the person. So the state and local agencies and the federal government cannot count those assets as available to the person. That's a great question. So that's a perfect question to segue now into what many of you have been waiting for, which is the explanation about special needs trusts. And Jeff, I'm hoping our viewers can see this entire slide in my webinar cue box.
Absolutely, Steve, yes.
Okay, very good. All right, so the trust that we are most concerned about in most cases is the third party trust. If you've never heard of this concept before, I want you to think of this trust as the trust that you as a parent, the trust that you as a grandparent or a sibling or an aunt or uncle or anyone would leave for a disabled person. This is called a third party trust because it is a trust. If I had the ability to illustrate this for you, I would show you to imagine a circle, and in that circle, this is where the funds are for the disabled person, and this trust is not considered to be owned by the disabled person. So the person that just asked the question about whether these assets are shielded for public benefit purposes, that is a wonderful question, because this is how it is shielded. It's shielded in the third party trust. Imagine the money coming from you, a third party, whether it is cash, whether it's life insurance, whether it's a retirement plan like an IRA, 401k, whatever it is that's coming from you into that trust, and it does not go to the disabled person first. That is a third party trust, and that's the most popular of all the special needs trusts. In practice, we call this generally a supplemental needs trust, but those two terms of art are used interchangeably, but technically speaking, this is a supplemental needs trust. So you see on this chart, anyone except the beneficiary can establish this, and at the death of the beneficiary, which is terrible to talk about, but at the death of the person many years from now, the third party trust has no payback to the state of Maryland or any other state. So in other words, the money can go to other beneficiaries that you've designated. So the third party trust is the most powerful tool that we have, and that's what we're going to really focus on here. Now you'll notice these next two categories, the D4A and the D4C trust, these are federally mandated trusts that the states have adopted. And these are trusts that can be used for someone, in the D4A case, someone who is under the age of 65. So let's say that someone passed away and left your disabled loved one assets that they shouldn't really own. I'll give you an example. Someone passes away and leaves a $500,000 brokerage account to a person who's on one of the waiver programs. And we've all heard about things like this, and I've actually seen it many times, and you may have too. Well, all is not lost, because what can happen is, now that that disabled person has received the money, which is not good, but that money can be moved to a first party trust. So these D4A and the D4C trust is called a first party trust. That terminology, if you think about it, will make sense, because now the person who is disabled, the first party, they received the money directly, and we must get that money out of their name if they're going to be eligible again for means tested benefits. So the Attorney General of Maryland approves this trust. It sounds complicated, but it really isn't. It's fairly routine. And the money is then transferred into that trust, and now we're back to where we want to be. The money is out of the person's name. The problem is it takes several weeks or even months to get this trust approved. So sometimes and many times it's a best practice for a family to actually create a third party trust and a first party trust at the same time. It is possible to have the first party trust, the D4A trust, approved by the Attorney General, and then just be sitting there really waiting to receive money if it needs to have money in it. Hopefully it will never need to be used, but it can be already set up where it's sitting there ready to be used. So notice that a parent, guardian, or a court, grandparent, or the disabled person themselves can create this trust. So there is something that occurred prior to President Obama's exit from office called the Special Needs Fairness Act. And now disabled beneficiaries, where they have mental capacity, they can create their own D4A trust. But remember, this has to be created and funded prior to age 65. Now, a couple of examples and we'll move on because we have to respect our time here. Jeff, when are we ending? Jeff may be muted. I think we're ending around 1 o'clock.
I'm sorry, 1:15, Steve. I apologize.
Okay, that's okay. I just wanted to make sure.
I was on mute.
That's okay. So we want to make sure that this trust is established so that we don't have to wait for a few months to get it approved. So that's a best practice. Couple of examples. Many of you have heard of terrible circumstances where someone's been injured in a car accident, whether they're a disabled child or not, or there's been a train accident. Something has happened, or someone is receiving a large settlement amount and they are disabled. Well, this is the kind of trust that is used for that. On a smaller scale, like the situation I was just describing to you, there is an advantage to this first party trust, and I want to share with you one little advantage. The first party trust is the only trust that the IRS has approved to receive an IRA without triggering taxation. So just to give you a little idea about that, IRAs cannot be owned by a trust during life, or it will trigger tax. But the IRS allows one circumstance where that's not the case, and that is if a disabled child were to receive an IRA, let's just say a $300,000 IRA that they really should not have received, it knocks them off of their means tested benefits. The IRS allows that IRA to be transferred and owned by the D4A first party trust without triggering tax. There are many private letter rulings that allow that. Many of you may be veterans or be receiving VA or military pensions, and the Congress several years ago approved that a military pension can be assigned to a D4A first party trust. So those things are what those trusts are used for. A D4C trust is a pooled trust, as you can see in this slide. It's for a person, generally speaking, that's over 65, and we can't use a D4A trust, although D4C trusts have some certain purposes that we don't have time to go into. The one disadvantage that we seem to be seeing with these kinds of pooled trusts is you can't necessarily designate who the beneficiary is, and I want to go back just a second to the D4A trust. Both of the first party trusts, the D4A and the D4C, at the death of the beneficiary, the assets are first payable back to the state of Maryland or any state that was providing the benefits. So just know that this is a payback trust, and we just want to make sure that we keep that in mind. We don't want to be funding a payback trust, although some families are not concerned about this. We don't want monies to go in here unless it's absolutely necessary, because we want monies to go to our other beneficiaries after the death of our disabled loved one. But just know that both of these first party trusts are payback trusts. The other problem that we are seeing with D4C trusts is it's allowable to create this trust. It's easy to create it, but there are certain states, and Medicaid in certain states is taking the position that a transfer of assets to a D4C trust by a person who's over 65 is allowable, but there is a transfer penalty for Medicaid purposes. So we're not too happy about that, and we think that is something that is going to be worked out. Hopefully, that it won't continue to go in that direction. So just know the third-party trust for estate planning, for special needs planning for families is our general focus, with the D4A trust being in a best practice or a perfect world, we would create that as well at the same time. So again, I've gotten ahead of myself a little bit, but you'll see the essence of what I've said on these following slides. A third-party trust is the best way to secure assets for a special needs loved one. There's no payback to the state of Maryland. Now, other than those three basic special needs trusts, there are families, and you may know some of these people, who do other types of planning, and those things can really have bad results. So let's talk about what happens there. What if we just leave an outright inheritance to someone who's on means tested benefits? Well, we know that they are going to have a loss of benefits, at least temporarily. We have to switch the money over to a first party trust where there's going to be payback to the state prior to any other beneficiary receiving it. That's just a bad outcome that we want to avoid. Assets can be left in a non-qualifying trust. What does that mean? Well, what if we leave assets for a special needs beneficiary on means tested benefits, and we leave that asset to a trust that allows for the payment of health, education, maintenance, and support as a standard? Well, that would be considered a support trust, and support trusts are going to be available resources that have to be spent down. So the person that asked that question earlier, the answer with the thing that we want to stay away from is leaving it to a non-qualifying trust. Where we have a disabled loved one and they clearly have special needs, we want to use a discretionary trust, which would be a supplemental needs trust. Leaving no money at all, disinheriting that person. We don't see that that's a viable way to go. And one of the reasons is, if we look at this list here, many of us know people that have done this. Well, I'm not going to leave money to my child. I'm going to leave it to my other neurotypical healthy child. Well, what do we have there? We have all kinds of things. That child who does not have any issues in life, when we thought about this, that person could have creditors. What happens when they die, and where do they leave the money? What if that flows to a person who's not going to use it for the benefit of our disabled loved one? What if there was a divorce? What if there was a car accident and forced them into bankruptcy? What if they had an IRS issue and the Internal Revenue Service levied that account? There's all kinds of things that can happen that make these kinds of arrangements very, very scary, and we don't recommend that anyone do that. So third-party trust, the beneficiary doesn't create it. We have all kinds of features that we want to talk about as contemporary features of this kind of trust, and we're going to get to that. There's no payback, as we mentioned. It can be revocable. I tell people, when I was a young lawyer, we used to draft these trusts as irrevocable trusts. Nowadays, many trusts like this are drafted as revocable trusts. That just means that they're flexible. You don't have to fund them during life, but if you decide to fund them, put some money in there, you can always take it back out at your death or on some other circumstance that occurs. It will become irrevocable, and we can make them very flexible or we can make them very conservative. So as a general rule of thumb, we want flexibility. We want to take into consideration all kinds of features, which we're going to talk about here. Choosing a trustee. This is one of the first things we really want to think about. Many of you already have a person in mind, or maybe you already have a special needs trust. There's a lot of things here to be thinking about. Should it be a family member? Should it be a professional of some kind? Should it be an independent trustee like a bank or trust company? Well, there are all kinds of complex things to know about. That's why I recommended you start reading that book. What about fees? What about knowledge and experience? If I use an independent trustee, how will I know that they're going to really, be on the ground and really understand my loved one's needs? So this issue of choosing a trustee is complex, and we're going to want to think carefully through that. A trust protector, we talked about this. So let's go to the bottom of this slide. This is a person who has flexibility, believe it or not, to direct the trustee and tell them, well, with regard to this particular thing, we're going to amend the trust, or we're going to change trustees, or I would like to review the accounting because the beneficiary can't review the annual accounting. Flexibility in drafting. That's what this trust protector provision is all about. And if you Google or look up trust protectors, you'll see that trust protectors came from other states like Alaska, Nevada, South Dakota, Delaware. These are asset protection jurisdictions where there's lots of complex trusts that can be created for asset protection. Well, some of the features from those particular states, like trust protectors, have evolved their way into everyday planning, and they provide flexibility. Trust Advisory Committee, you'll see at the top of this slide. What if there's a crisis? I've actually had this happen. I hope your situation is different. I've actually seen this as I'm a trustee of certain special needs trusts. What if there's a crisis? What if I, as a trustee, don't know what to do? What if the trust protector doesn't know what to do, and the social worker? What if we have to bring in an expert like a psychiatrist? This particular provision gives the trustee the flexibility to be able to create a committee of people. It's not easy to do. It's not easy to pull these people in. Some of them, by the way, will serve for free. But what we recommend is that you put a provision in there that reminds the trustee, this is what you can do. Don't forget this, okay, if you have a crisis. There are some times when we're drafting trusts that certain families do not want this provision in there, but we recommend that it be in there as an option for the trustee. This is a visual representation of what it looks like to have the trust here. The special needs trust is the core, but these little circles that are surrounding the big circle, these are the considerations that we think are part of the discussion of modern special needs planning. So as we look at this, we talked about trustees. That's a big issue. We're going to see another slide about that. Selection of special fiduciaries like trust protectors. I know this is a lot to think about, but that's what the planning process is all about. Maryland ABLE, we're going to talk about that. The trust should say that an ABLE account could be funded if the trustee thinks it's a good idea. We want to provide for advocates. Here again, we're giving the trustee a set of instructions. I'll stop for just a second. Would you believe if I told you that the average trustee probably does not read the trust? That is true. I hate to say so. So we want a trustee that is going to read the trust, read the book. We want a trustee that's going to look at the trust provisions and say, wow, now that I've read this trust is telling me what to do. It's telling me what I can do, and it's acting as a set of instructions and not just a bunch of legal provisions. We talked about the memorandum of intent. We want that to be a part of the trust in some way. Again, we recommend that this be an attachment and that you update it every 3 to 5 years or more often. The Trust Advisory Committee, we just talked about that. And now let me talk about special requirements or considerations for retirement plans. Many of you on this call have IRAs or 401ks, or if you're an educator, a 403B or a 457 plan, whatever it may be, If you pass away and leave your IRA to a special needs trust, well, I have good news for you. The special needs trust is exempt from the recent Secure Act, SECURE, the Secure Act. Some of you have read about this, but it was legislation that was signed by President Trump on December 20th, and it became law on January 1st. If you have healthy children, children without disabilities, they will not be exempt from the Secure Act. And that means that they will have to take their IRA, inherited IRA from you. They will have to take that someday when you leave it to them in 10 years or less. That means they have to take all the money out in 10 years or less. But the good news is that your disabled loved one is exempt, or your chronically ill loved one is exempt under the Secure Act, and they will be able to take the inherited IRA and stretch the taxation of that IRA out. You may have heard of this, the stretching of the IRA. They can stretch that out over their whole lives, which is a very, very good thing because it allows the undistributed amount of the IRA to continue to flow, or to grow, I should say, tax deferred. And the good news is, even though all the rules and regulations are not out about the Secure Act, we do know that special needs trusts are exempt. So your disabled loved one is exempt from the Secure Act, the special needs trust is exempt, and therefore distributions of an IRA to a special needs trust mean that the special needs trust, if it is drafted right, and that's a big caveat, if it is drafted right, will meet the requirements of the Secure Act, and your loved one will be able to stretch out the benefits of an IRA for their lifetime. So I want you to just get your mind around this slide. And now we're back to trustees here just a little bit. Jeff was kind enough to put these nice looking people in here. And he says the reason he chose these photos is that he found out these people are perfect. They are the perfect examples of trustees. They advocate for the best interests of the person. They understand public benefits. They promote the quality of life of the person. They keep perfect records. They financially are very savvy, and they know how to invest. And I say all of that a little bit of humor, but I also say that just as a very good rule, or a good admonition, I guess, to you, that this issue of trustee selection is crucial. And one of the reasons that you also want to make sure you have a trust protector, just in case the trustee's life changes, their situation changes, they're not doing a good job, God forbid, they need to be replaced. You have a trust protector flexibility in there. Now, a lot of you are concerned about what can a special needs trust pay for? Well, basically, they can pay for anything for the benefit of the beneficiary. With a D4A trust or first party trust, it has to be for the person's sole benefit. Jeff and I have some lists of approved expenses that a trust can pay for. Basically, with a third party trust, my point of view is anything that's in the interest or for the benefit of the beneficiary can be paid for from the trust within reason. And of course, there's no payback to Maryland. And the third party trust is not as scrutinized as the first party trust, which is scrutinized by the state of Maryland once a year and by Social Security. Now we get back to this issue real quickly. How much should I fund in the special needs trust? Here again, I want you to consider not only your current financial resources and understand I am not a financial advisor, but I want you to think in terms of collaborating with your special needs attorney, your elder law attorney, and your financial advisor in a collaborative team, and a CPA if appropriate. And by the way, CPAs can be extremely valuable and should be part of the team to decide how are we going to properly fund this trust. Remember, in a perfect world, we all would buy permanent life insurance like whole life or universal life or some form of permanent life insurance to make sure that trust is going to be funded for sure someday. But not everybody is in that position. So we have to use our resources to make projections. And if you do not have a financial advisor, I strongly encourage, or a CPA, please let Jeff and I know, and we can give you several names, and we can even help you interview those folks. First party trusts, we talked about this. These are trusts that are used in litigation or where someone has received money they should not have received as a special needs beneficiary in their own name. They are payback trusts. And again, this slide will remind you of that, the types of situations where these are used. And again, in a perfect world, we would take the time to establish this kind of trust from the outset, even though we don't anticipate that it's going to receive money unless the person has received money in their own name already, or they are going to receive a military pension. Now, what is the process of establishing a trust? So let's just get into that. I apologize about this rather unusual drawing. We had a graphic designer create this. It's designed just to show you that we believe special needs planning should be a step-by-step process. And the long and short of this funny looking illustration is that we want you to collaborate with us and your financial advisory team and tax team. But if you look at the circle on the outside, we really want to go through a series of review. 1, 2, 3, 4 meetings at least of review and discussion, because these are important issues. Who are going to serve as your fiduciaries? How should we structure this trust? Should it be conservative? Should it be more liberal? All of these provisions and thinking. So we just encourage time to think, and this is a visual representation of that.
Steve, can we ask a couple of questions, some good questions here, since we're on the topic of trust. Question I think you alluded to the answer to just a minute ago. If a person receives settlement funds from malpractice lawsuit at birth, it sounds like D4A is the best option.
Well, yes, that's a great question. So I'm going to say I can't give legal advice about that particular situation without knowing more about it. But generally speaking, if the beneficiary is under 65, there are statutory trusts, which I don't want to confuse. It's not absolutely essential that it go into a D4A trust if a person is a minor, but generally speaking, these trusts are going to receive, after a court litigation and after a petition to the court or the establishment of a first party trust, most of the time, that in my experience, that trust is going to receive those kinds of funds, because the idea is, even if the person is receiving a malpractice settlement, and maybe it's large that they're receiving, hopefully it is if it's a bad situation, but the idea being that even that large amount of money may not be enough to take care of that person for their entire lives. So generally speaking, that kind of money is put into a trust. Now, with that said, it depends on the disability of the person and the extent of the disability, and it may be necessary to get a life care plan done as part of that whole process to see whether the money should be protected or not, what benefits and what things the person is going to need in their life in the future. So I would say a great deal of the time that will happen, but not always.
Thank you. The next question is, I currently have life insurance via employment with disabled son as beneficiary. Should I establish a third-party trust and designate trust as place to place money, or should the trustee be the beneficiary?
Okay, that is a wonderful question. Thank you. So I would say, depending on the disability of your child, is going to determine a couple of things. Should he or she have a special needs trust? And if the answer is yes, let's say we know we need a special needs trust to manage creating this world of support for them in the future, and to keep them eligible for means-tested benefits. If the answer to that is yes, then I'd say you want your life insurance in that particular case, not knowing all the particulars, but from what you've described, we want that trust to receive the life insurance proceeds and not the child. Because if the child receives those proceeds and is on means-tested benefits, then we are back to having to put that money into a first-party trust to get him or her back on those means tested benefits, and the first party trust is a payback trust. So I think generally speaking, you would want those proceeds to go to the third party supplemental needs trust and not to the child.
Very good. Thank you, Steve. Another question. My disabled sister, age 60, receives child disabled benefits, Medicare, and Social Security from deceased parent and Medicaid. Does she need to apply or do anything differently to Social Security when she turns 62, 65, 72, etc., or no action necessary, continue as is?
That's a great question. My initial reaction is to say probably she doesn't have to do anything, but I think if you could pose that message, that question in an email to us, again, we would have Megan McCullough give us the fine details on that about whatever might need to happen. But I don't believe anything's going to be needed because this is a disabled adult child.
Another question, is periodic review of trust documents recommended? How often? In concert with trust attorney?
Excellent question. So to try to answer this, I will start by saying that many estate plans will fail because they are never updated over the years. And those of you who may have heard me speak before, I apologize, I'll say it again. The average person who does estate planning, and remember, most people do not, but the average person who does, which is the minority of people, that person does not update their estate planning on average for about 20 years at a time. It's about 19 years at a time. So that's not good statistically. So if we can beat that, if we can beat those statistics, the better we do that, the better our chance of success is. So I would recommend, if we have a client care program, for example, at our firm, and that's not what this program is about, but our client care program is designed to encourage people to update. So whether you join our client care program or not, what we want you to do is think in terms of updating or at least sitting for an hour every 2 or 3 years at the most. Has anyone become ill? Is anything different? How is the beneficiary doing? Do we need to update the memorandum of intent? So I think based on your age, especially if you are older than 60, I would recommend at least every 2 or 3 years. And for those folks that are over 70, I would say you should spend about an hour every year or two with your estate planning attorney just to make sure nothing has changed. No changes in the laws, which of course are always happening. That's the way to make sure the estate plan works.
Thank you, Steve. We do have a couple of questions about Maryland Able. I thought we might hold off on those until we get to that last portion.
Right. And I promise we're getting there. I've already kept you quite some time. We have about 10 or 15 minutes left. I just want to cover this issue briefly again about guardianship. Guardianship is a process. It is an invasive process. It is the process that really takes away the legal rights of your loved one or an adult who is disabled. Guardianship has its place. Guardianship is the measure of last resort to actually get a court order. And guardianship is there for a reason. Many people do need a guardianship, and many young people, when they turn 18 or 19 or 20, they do need a guardianship. Their parents need to get guardianship of the person, at least over their person, their health care, where they live, and perhaps if the person has funds in their own name, get a guardianship of the property. So this is all a counseling issue, and many parents are very torn about this. So this is something that's part of special needs planning about the counseling aspect of this. Again, alternatives to guardianship are the person, if they have the mental capacity and they are not extremely vulnerable, to sign power of attorney or advance directive to substitute those agents for a guardian. And then hopefully in the future, we're going to have a supported decision making as some kind of middle ground between the one extreme and the other. And again, I just mentioned this, the guardianship of the person or guardianship of the property or guardianship of the estate, as this slide calls it. And For many parents, this is a source of anxiety, and sometimes it just takes about an hour to explain this. This is the process. This is what's going on in the process. This is what you can expect from the court system. This is what the process is all about. And many times that clears up a lot of the anxiety. So what we want to do generally is really not fear the process of really talking about all of this. It is overwhelming for a lot of people, but what we do here at our firm, for example, we talk about these things on a no-cost consultation basis. So for us, estate planning, special needs planning, this is very synonymous with, we usually spend about an hour and a half with clients to really just discuss all of these issues in depth, and we don't charge for that. And then at the end of that, we decide whether we should move forward with an estate plan, with a special needs plan. There's an estate planning questionnaire, and there are some materials that we would send people who are interested, and we would ask, it's a little bit of work, we know that, but we would ask that you complete this information, because when you are doing planning with someone, you are giving them a lot of information, but for us to have the information is really the only way we can help and that we can properly advise you. Again, there's nothing to fear. We want you to have a place to think, a place to relax, a venue where you have a chance to really consider these things. And we of course want you to prepare questions. Many of you have had great questions today, and we have a few more. And again, the idea here is counseling. Counseling through the process creates a wonderful estate or special needs plan. And then the maintenance and updating. That one person had a wonderful question. What do I do to maintain and update my plan over the years? If you maintain and update the plan over the years, taking into consideration changes in the laws and your financial condition, all of those things in collaboration with your team, you're going to have an estate plan that works. You're going to be intentional, which is something that I will be coming out soon with a book about the issue of being intentional in estate planning and what I would call intentionalism. So all of these things go to the issue of good planning. So we want to create memorandums of intent. Remember, you can request one of those from us if you want one. You can establish your own estate plan. You can establish a special needs plan. We will show you how to do that. There are simple ways of doing it, and there are more complex ways of doing it. We want to take into consideration your financial needs through a collaborative team. We want to consider things like changes in the laws, like the Secure Act. And we want to understand public benefits. That's key. We want the trustee to understand that. So we want you to start thinking in general, who are the people who are my trusted fiduciaries? Who are my advisors? Who are my trusted loved ones or friends? Who would be my trust protector? And again, you don't have to figure all this out on your own. We will help. If you were to choose to meet with us, we would work through those issues with you. So with that said, we're going to get to Maryland Able. But before we do, I just want to say, so far, thank you very much. I know we have a couple more Able questions. We do presentations with Kelly Nelson of Maryland Able and the other executive director there at Maryland Able. So we're very fortunate to be able to present with them. We have further information about Able that Jeff will send you. But as we wrap up with Able, I'll just say thank you, and I hope you'll complete your evaluation. And we want to encourage you, if you have existing documents, we're happy to review those for you at no charge. And if you would like to consult with us by telephone or by video, we are happy to consult with you at no charge as well. So we're very fortunate to serve and be in the special needs planning community, and we thank you. So Jeff, with that, I'm going to say, what are our Able questions?
Well, we have one other question before we jump into those, which is a very good one. So what should come first? A meeting and plan with a financial advisor, or a consultation with your office, or I guess an estate planning attorney? By the way, would you share a few financial advisors that we could interview? And then there is another question.
All right, so this one, thank you for that question. So yes, we have many financial advisors that we're happy. If you will give us an email, we will email you. Now, I just want to take 1 minute on this. There are many, many wonderful financial advisors and friends of Elville and Associates, people that we've worked with for years. There are certified financial planners, which are the highest certified types of financial planners. Then there are folks that are wonderful financial advisors, but they are not certified financial planners. And then there are financial advisors who really have no experience or no personal experience with special needs. And then there are an increasing number that we have met over the years that do have special needs children of their own and understand more about what you need. I would say that that's not a particular reason to use one or the other, but I would encourage you to interview them, and we will help you do that if you would like us to and facilitate that for you. I will say that many people probably will have their planning driven by good advice from a financial advisor. But if you are coming to planning for the first time or maybe a second time, and it's not because of a financial advisor, it's just because you know you need to get an update of your documents and so forth, then I would say your documents and your consultation and your special needs and estate planning would come first, because we are then going to tell the financial advisor, or you, if you don't have a financial advisor, we're going to help you align your assets. So estate planning is about documents, it's document driven, but we then want to make sure that your assets are properly aligned. You can have a wonderful estate plan, but if your assets are not flowing properly, your estate plan may not work the way you want it to. So I would say if you're already with a financial advisor, we know you're already getting good advice. You'd want to go ahead and start the planning. If you're not with a financial advisor, I would say you should start the planning, and then we will drive your planning in coordination with a financial advisor to make sure that the assets are flowing the way they should. I hope I've given you something to go on there, and I hope you will email us and we can help you with the financial advisor choices.
One other brief question, Steve. Discuss briefly the income tax issues on income earned in a third-party trust.
All right, that is a great question. Thank you for asking. I will make sure we have a little bit of time for Abel, so I'll be brief on this. If we make a third-party trust a revocable trust, remember that a revocable trust is ignored by Uncle Sam. So let's pretend it was a revocable trust and it made you happy to put some money in there. And so let's pretend you didn't have to, but you put $50,000 in there during your life. You're going to continue to claim the income tax or the income on that $50,000 on your own personal income tax return, because that is a revocable trust. It does not require a separate tax return. So that's why it's more convenient and least confusing way of doing planning, unless there's a specific need to have it as an irrevocable special needs trust. Now, if we had an irrevocable special needs trust and we put a significant amount of money in there during life, then that trust will create enough income to have to pay taxes on its own. So the trust would pay the tax and not the individual. So the income tax ramifications of an irrevocable trust are such that during life, it would require its own tax ID number and would require a 1041, which is a fiduciary income tax return. But if we make it revocable, we don't have to deal with that. The first party trust is an irrevocable trust every time, and it is going to require a 1041 every year. At death, and whether it's a first party trust or a third party trust, the trust is going to be its own tax entity. So the trust will pay its own income tax, and it's too much to go into today, although it's a wonderful question. If income is passed out to the beneficiary, then the beneficiary will pick up that income tax on their own return and pay less tax, most likely. But during life, we want to keep it simple most of the time with a revocable trust where we don't really have income tax ramifications.
Okay, Steve, you wanted to go through some of the Able slides,
all right.
do that and then answer the questions at the end.
Thank you. So I'm just going to go through this very briefly. We only have about 5 minutes. So Maryland ABLE is now a very wonderful and established thing. The ABLE account is a tool. It is not a special needs trust. It is a way to enhance someone's life. I'm just going to make sure I summarize this for you, even though you're going to see these few slides. The person has to be disabled prior to age 26, although there is legislation and a movement to try to increase this age. It's felt that this is unfair. The person has to be disabled. And of course, contributions to this account are $15,000 per year maximum. And let's just say that a person on SSI can have $100,000 in this account eventually without losing their SSI benefits. So for this account can actually have up to $500,000 in it, but for SSI, it can only have $100,000. So in the beginning, this federal law, which was mandated to the states, this is technically a payback account. So technically speaking, at the death of the beneficiary, this account has to be first paid back to Maryland or any other state where the child lives, similar to a first party trust. However, Maryland has opted out of that payback provision. So right now, even though the federal law says this is a payback account, Maryland is not taking that position because apparently it's quite a lot to try to administer this. And Maryland said, we're not even going to try apparently to keep track of what is paid back to the state of Maryland. With that said, only certain expenses are approved to be able to be paid out of this, and it's quite liberal. And Jeff has some examples that he's happy to send out to you if you're interested. Here's a little bit of what we would call qualified disability expenses. But in the interest of time and in the interest of ending on time, and as you can see, there are a few tax incentives here. I just want to say that from a special needs planner, a point of view, the ABLE account is a tool. If your loved one is high functioning, then this person is going to enjoy having certain freedom with their own ABLE account. As you can see, there are certain cards, we might call them prepaid cards, or we might use something called a TrueLink card, where you can control how much the person is able to spend from their ABLE account. But this is about enhancing someone's life. There's no question, it's a wonderful thing. One thing I like to point out to parents, if your loved one is disabled and obviously disabled, but if the person is vulnerable and they are not under guardianship, then remember that the ABLE account is technically owned by them. It is in their own name. If you are their guardian, then the account is technically not in their name, and they would not have full control over the account. So you just have to be aware of that. But previously, remember we talked about the HUD issue, where the beneficiary lived in HUD housing or lives in HUD housing, and his mother was able to start contributing to an ABLE account, and it did not affect his income. It did not affect his rent. So that was a wonderful and powerful use of ABLE. Another example is, what if the child receives money and they're not supposed to have it in their name, and it's a relatively small amount of money, and we need to get it out of their name right away. Well, we could, by putting it in an ABLE account, we can get that money out of their name right away. So there are uses and tools, or uses of ABLE as a tool that are very, very advantageous to use it in the proper way for the right person. But it does not substitute for a special needs trust for various reasons. But again, it is a wonderful thing. You should explore it, and you should contact Kelly Nelson at ABLE, and we will help you do that if you would like to. Jeff, I'm going to end there and take some questions, and then I think.
So very good, Steve. Yeah, Miss Kelly Nelson, who we've presented with many times before, she was nice enough to let us use her slides that we typically present with her on. She can be reached at knelson, NELSON, at marylandable.org. She's always very responsive and able to answer any of your questions. A couple questions regarding ABLE. I have two disabled sisters who have Maryland ABLE accounts. when one sister dies, does her able money get transferred to the second sister? I recall reading something like that when I opened accounts for them. What happens to the money after the last sister passes away?
All right, that's a great question. I believe I have sat through many of Kelly's presentations, and I believe Maryland Able says that that will pass by way of the estate of the sister, of the respective sister. Now, I don't know, I'd have to ask Kelly specifically whether one sister can designate another as a beneficiary. I have not heard that that's possible. So my reaction would be to say that is going to pass according to the estate of the deceased sister and will not pass to the other sister, but I'll have to let Kelly expound on that.
Steve, of course, I'm not an attorney, but I've also sat through many of Kelly's presentations, and I would agree with that statement.
Okay.
I think you're right on point there. Let me try to find the other question here. Bear with me just 1 second.
We hear you hard at work there, Jeff.
Yeah, we had a lot of great questions here. Bear with me just 1 second. I'm getting there. I know there were two. Hang in there with me 1 second here. You know, I don't seem to see it. Maybe it was just one.
Okay.
Oh,
Well,
wait a minute. I apologize. Here it is. Okay.
Okay.
And then we'll finish. If ABLE is not paid back to Maryland, then does my adult disabled sister need a will to tell where or to whom her ABLE money goes after death? She has no guardianship and no trust.
Right. So based on what we've learned from ABLE, if that's the case, then I would say she should have a will if she has mental capacity to sign a will. And the mental capacity to sign a will is not great. She just needs to understand, what her property is and basically and who she wants to give it to, so to speak. But if she doesn't have a will, it will pass by the laws of intestacy, and we'd have to see who are the surviving heirs at that time to see if it would pass to the other sister. But generally speaking, yes, she should direct where estate-driven assets would go through having a will. All right, Jeff, well, I'm going to turn it back over to you. We've gone a little bit over, and I just want to thank everybody for being on the line. And Jeff, I will on the webinar, I should say, and I'll let you wrap up, Jeff.
Sounds great, Steve. Thank you so much, everybody, for being part of our webinar today. We appreciate it. I'd like to give Steve a virtual hand for his great information and efforts today. Please do take a few minutes to provide your comments to us and your feedback. We value it as we keep working to perfect our presentations and our webinar experience. We really appreciate that, your comments, and if you're interested in a consultation with Steve, we would really appreciate that. Couple final thoughts. We have a couple of other webinars coming up with Steve on Monday, May 11th, our Estate Planning Essentials, which is a very popular program. Also on May 20th, from 12 to 1:30 with Olivia Holcomb-Volke, one of our partners here, estate planning specifically for young families and young parents. So that'll be an interesting program as well. Also, I'd like to again thank Kelly Nelson from Maryland Able for allowing us to use her slides today. We'd like to thank you again for being here. Any other questions, feel free to send them my way or Steve's way, and we'll get you an answer. And I did get some feedback on the dashboard here that people are requesting some information, and we'll get that to you in a timely manner. So thank you again. Have a wonderful day, and we'll see you again.
Thank you.